Oh, good evening. My name is Greg Scott. I'm the Senior Vice President of Communications at Alliance Defending Freedom. And on behalf of ADF, I'd like to welcome you to American Culture on Appeal, which is an event series that brings together advocates, scholars, and experts to engage in civil discourse on some of the most challenging and at times divisive issues of our day. Alliance Defending Freedom is the world's largest legal organization committed to protecting fundamental freedoms like free speech, religious freedom, and the sanctity of life, marriage, and the family. Since 2011, ADF has won 14 Supreme Court cases. Since 1994, we have played a role in more than 70 Supreme Court victories. Tonight, you'll hear from an esteemed panel of experts who will discuss 303 Creative v. Elenis, one of the most important free speech cases at the High Court this term. Lori Smith is an artist who runs her own design studio, 303 Creative. She's a visual storyteller who specializes in graphic and website design. Lori left the corporate world in 2012 to start her own small business so she could promote causes consistent with her beliefs through her art. But a Colorado law censors Lori's expression and requires her to create designs that violate her beliefs about the institution of marriage. Lori enjoys working with people from all walks of life, but like most artists, she can't promote every message she's asked to promote. She decides which projects to design based on the message requested, not the person requesting. After realizing Colorado was censoring her and seeing the state use this same law to punish masterpiece cake shop artist Jack Phillips, Lori challenged the law to protect her freedom and freedom for all Americans. In July 2021, the 10th Circuit ruled against Lori, holding that Colorado can censor and compel her speech. Lori appealed to the Supreme Court, which granted her petition for review. Oral arguments in 303 Creative v. Elenis are scheduled for December 5th, 2022, and will be argued by one of the panelists here tonight. This event is live streamed, and throughout this evening, we invite you to share your thoughts on Twitter using the hashtag SCOTUS, SCOTUS, and tagging at ADF Legal, at ACLU, and at Sherif Girgis. At the end of our panel, we'll open the floor for a question and answer session with our panelists, moderated by the gentleman I will introduce now. Mark Sherman has covered the Supreme Court for the Associated Press since 2006 and has been with AP since 2001. In 35 years as a reporter based in Washington and Atlanta, his previous beats have included the Justice Department, healthcare, and national politics. Mark worked for the Atlanta Journal-Constitution and briefly was a Foreign Service officer. He is a native of Brooklyn, a graduate of Princeton University, and a resident of Washington, D.C. Please welcome Mark Sherman.
Well, thank you, Greg, and thank you, everyone, for being here tonight, and also to our panelists. You're not here to listen to me, so I'll get right to it. I want to introduce the three panelists. Among them are two lawyers who opposed each other in the Masterpiece Cake Shop case, the precursor to this one, and one of whom will again try to persuade the court in December, and as well a legal scholar and former Supreme Court clerk. Sherif Girgis is an associate professor of law at Notre Dame Law School. His work at the intersection of philosophy and law, including criminal law, constitutional liberties, and jurisprudence, has appeared in many academic and popular venues, too numerous to recount here. He is the co-author of What is Marriage, Man and Woman, a Defense, cited in a dissent in U.S. v. Windsor, and Debating Religious Liberty and Discrimination, released by Oxford University Press. Prior to joining Notre Dame, he was for a time at the Jones Day Law Firm in Washington, D.C., and served before that as a law clerk to Justice Alito, and as well to Judge Thomas B. Griffith of the U.S. Court of Appeals for the D.C. Circuit. He's now completing his PhD in philosophy at Princeton. He earned his JD at Yale Law School, where he served as an editor of the Yale Law Journal and won the Felix S. Cohen Prize for Best Paper in Legal Philosophy. He earned a master's degree in philosophy from the University of Oxford as a Rhodes Scholar and a bachelor's in philosophy from Princeton, where he was Phi Beta Kappa and graduated summa cum laude. David Cole is the National Legal Director of the American Civil Liberties Union and the Honorable George J. Mitchell Professor in Law and Public Policy at Georgetown Law. He is a regular contributor to the New York Review of Books, legal affairs correspondent for The Nation, and an award-winning author or editor of 10 books. He has litigated many significant constitutional cases in the Supreme Court including Texas v. Johnson and U.S. v. Eichmann, which extended First Amendment protection to flag burning. He represented the gay couple denied a wedding cake in Masterpiece Cake Shop v. Colorado Civil Rights Commission, which, as I said, is the precursor of the case we'll be discussing tonight. Kristen Waggoner is the CEO, President, and General Counsel of Alliance Defending Freedom. The organization describes its mission as protecting fundamental freedoms and promoting the inherent dignity of all people throughout the U.S. and around the world. Waggoner oversees the efforts of more than 400 ADF team members in 7 global offices, as well as 4,500 network attorneys engaged in litigation, legislation, training, funding, and public advocacy. ADF also provides legal counsel to over 3,500 churches and ministries through its Ministry Alliance program. She has previously won 2 cases before the court, including the Masterpiece Cake Shop case, and she will argue her 3rd case in December. She previously clerked for Justice Richard B. Sanders of the Washington Supreme Court after law school and served in private practice in Seattle for nearly 20 years. We'll start with Sherif.
Thank you. I'm really grateful to be here, grateful to ADF, grateful especially and very honored to share the panel with David Cole and with Kristen Waggoner. I should apologize in advance. My voice box this morning, for reasons of its own, gave out. And so I'm going to try to speak forcefully, and I'll make up for it by starting with some bombast. So I think that this case raises lots of difficult and interesting issues, especially in terms of where to draw the line. But in terms of the bottom line conclusion, I think it's a straightforward case. And with the media present and 200 witnesses, I'll tell you, I think it'll be at least 7-2 in favor of 303 Creative. I think it would feel likelier to be a straightforward case if the political valences were flipped. So in DC, for example, it's forbidden to discriminate based on political affiliation. So suppose some member of the Proud Boys went to a website designer and said, I'm going to have a party to celebrate the anniversary of January 6th, and I want you to make the website for it. Or if a pro-life person or a conservative person said, I'm going to have a party to celebrate Dobbs, and I want a website done, and a pro-choice website designer objects. The reason, apart from intuition and those kinds of examples, that I think is straightforward is that I think the answer follows from Hurley, which is a decision that was decided unanimously, including the votes of Justices Breyer and Souter and Ginsburg. And it was a decision that said, drawing on a long line of cases, that said you cannot discriminate, that you cannot compel someone to say or make or do something expressive, carrying a message they reject, unless there's a compelling interest. And that was a case involving a parade organizer that was asked to allow a gay pride float in the parade. And the court unanimously said you cannot make them do that. And applying those 3 principles here, I think the answer is clear. So A, I don't think anybody, including the 10th Circuit ruling against 303 Creative, the state of Colorado, or the ACLU, would deny that websites are expression. They involve words and graphics and art, and that's paradigm First Amendment speech. Second, does it carry a message? In this case, does forcing the website designer to create a website celebrating a same-sex wedding, does that carry a message she rejects? I think it's pretty uncontroversial. It does contain a message. Here's a couple, their relationship is going to be a valid marriage, and that's to be celebrated. So all the action, I think, is on the 3rd step. Is there a compelling interest to force the designer to create the website anyway? The most common proposal is that there is because of the interest in fighting discrimination. And that's obviously a very important interest. But in Hurley, the case I mentioned, which was an anti-discrimination case involving sexual orientation discrimination, in a public accommodations context in particular, the court said, no. Of course, in general, these laws are valid, but when they effectively deem a form of speech to be the public accommodation, they cannot be applied in that way, because then they are compelling speech. Another way to see it is that the discrimination at issue here is the act of discriminating in or making a choice about which messages to convey. So to say you can regulate speech for that purpose is to say that you can regulate speech for the sake of regulating speech, which is no good. So the best counter-proposal, I think, is to say, well, there's some more concrete harm at issue. It's not just the generic interest in discrimination. And one proposal would be that there's material harm, that gay couples are being denied access to goods or services, In this case, and in the butcher, baker, candlestick maker, all the other cases involving wedding services, nobody has ever claimed that because it's never been true, given the facts on the ground. So the best proposal is that there's dignitary harm, that the denial of these services sends an offensive and demeaning message to the gay couple that's been turned away. And I think we cannot deny that those kinds of interactions and messages can be deeply harmful, and very often are deeply harmful. But Hurley answers that argument straightforwardly. It says that's a decidedly fatal objective for an attempt to control speech, because it's the bedrock principle of our First Amendment law that we cannot, that the First Amendment is there to protect the speech that we hate. The fact that it's deeply offensive is not to be denied. It's a genuine pain of living in a society where people disagree, but it's actually a reason to strengthen First Amendment protection, because the point of the Free Speech Clause is to protect minority, dissenting, and deeply offensive views. Thank you.
Dave?
Thanks. Also honored to be here. I have a little bit of a different point of view, as you might imagine. No one is required to open a business to serve the public. Artists, writers, don't generally do that. I'm a writer. I write for certain outfits. I don't write for other outfits. I'm not serving the public. Public accommodation laws don't govern me, and don't govern most artists, most writers, most painters, most sculptors, etc. But if you choose to open a business to serve the public, it's long been the rule, and it's the rule in every state in the country, that you have to serve everybody equally. You can't say, I'm serving the public, but I'm not going to serve gay people. You can't say, I'm going to provide a service to opposite-sex couples, but I won't provide that same service to same-sex couples, because now you're not open to the public. You're open to the public minus same-sex couples. All the Colorado law does is what every public accommodations law does, which is to say, once you decide to open a business to the public, which was her choice, she decided to do that, now you have to serve the public. The law also does not require you to make anything in particular or to say anything in particular. It simply says that if you're going to provide a service to one, you have to provide it to all. You can't discriminate in who you provide service to. Now, a half dozen times the court has faced arguments that the First Amendment gives businesses the right to discriminate. Businesses open to the public. Every time it has rejected that argument. Religious restaurant didn't want to serve black people because it was against its religion. Court said that's essentially a frivolous objection. A religious university didn't want to admit mixed race students or in mixed race couples because they religiously objected to that. The court said that's not a justification for discrimination. A law firm and some business associations said they wanted to discriminate against women, or that they should be free to discriminate against women as a right, as an exercise of their First Amendment right of association. The court rejected all of those claims. Law schools argued that they wanted to, they shouldn't be required, compelled to speak and to provide services to the military on equal terms to other recruiters because they objected to their, the military's policy with respect to gay members. The court rejected their argument. And then in Masterpiece, which we argued, Kristen argued that the First Amendment gives a baker the right to refuse to make a cake for an opposite-sex couple, that, for a same-sex couple, that he would have made gladly for an opposite-sex couple. And the court refused to rule on that basis and said, in fact, the general rule is that philosophical and religious objections do not permit a business that is open to the public from evading the non-discrimination requirement of public accommodations laws. So that's all that's at stake here. I mean, it is not a compelled speech case. It is a requirement that once you choose to provide something to customer A, you can't deny it to customer B. You don't have to provide it in the first place. But if you decide to provide it to customer A, you have to provide it to customer B. And imagine the world if, in fact, the court rejects these half dozen cases and 7-2 says, actually, anyone who's providing an expressive service and objects to the message that is being asked of it can discriminate. Well then, a baker that is racist and doesn't think black lives should be celebrated could refuse to sell a happy birthday cake, a cake that says happy birthday, so is expressive, to a black family. Because remember, it's not just religious beliefs. It is any First Amendment. The First Amendment protects racist beliefs as well. So let's take a architect who doesn't believe that we have too many Mexicans in this country. And so an architecture company puts on their sign, we will design houses. It's an expressive function, but no Mexicans need apply. Because that would express the message that it's okay for Mexicans to live in this country, and I object to that, and that's a First Amendment protected objection. Or let's say you are providing editing services for college application essays. And you're a corporation, you decide to go into business for the public, but you know what? You think there are just too many Asians in elite colleges today. So you say, we're providing editing services. It's an expressive service, but we're not going to provide it to any Asians because we object to Asians being admitted to elite colleges. Under the argument that is being advanced by Kristen and others before the court, all of those businesses would have the right to discriminate. And is that a world we want to live in which all sorts of businesses that are expressive in one way or another, and lots of businesses are, can put up signs saying, no Catholics need apply, no Muslims need apply. We don't serve women. I don't think so.
That is not a world I want to live in. But thankfully, we don't have to, even if we win this case in Lori Smith's situation. I want to thank you all for being here tonight, and I especially want to thank you, David. In this social media environment, it's easy to stay in our echo chambers, to not engage when we know we're going to disagree on important issues. And I've been on panels where I've been the one, and so I'm just especially grateful that you would come, that you would model civility and kindness, and yet express your views clearly and forcefully. So I'm looking forward to a good evening. Thank you to Sherif as well for your contributions, and also to Mark for keeping us all in line and moderating. I think that however you define marriage, my hope is that tonight you will come out of this time together with support for Lori and hoping that the U.S. Supreme Court will protect her right to free speech. In terms of why that would be, it's because that freedom protects everyone, not just Lori and not just those who are on one particular side of a debate, or even those who happen to agree with the government's position at a particular time on a particular issue with a particular administration. I think we're living in a world where we don't want to rely on the government alone to decide what we can and can't say in this moment. Frederick Douglass said that liberty is meaningless where the right to utter one's thoughts and opinions has ceased to exist. That of all rights is the dread of tyrants. In fact, it is the right which they first of all strike down because they know its power. In 303 Creative, the Supreme Court will decide how meaningful that promise that Douglass talked about is in today's environment. And at Alliance Defending Freedom, I want to make it very clear tonight that we support the right of every artist and every American to be able to speak freely, regardless of how they identify, whether they're Democrat or Republican, whether they're Muslim or they're atheist. We have the privilege of representing Lori, who wants to share her beliefs about marriage. But all of our beliefs are at issue in these kinds of cases. And at the outset, I just want to stress two significant overarching points that I think sometimes we forget in these discussions. The first is that this right to free speech doesn't come from the government. We're not lucky to have it. It is a pre-political and inalienable right that we all benefit from, that's rooted in our human dignity, the dignity that we all have no matter our viewpoints. A second thing that I think sometimes gets lost or forgotten or may not be known is that many countries in the world have free speech protections in their written constitutions. Their governments provide similar liberties that we have when it comes to speaking freely. But activists and government officials have steadily undermined those rights, and they've lost them. And what you may not know right now is that we're the last Western country in the world that continues to have robust free speech protection and that has resisted government compulsion, government censorship laws, like what is being seen right now throughout Europe, Canada, Australia, and New Zealand. Our First Amendment serves as a citadel against the tyranny and the authoritarianism that Douglas feared. It also gives us the right and assures us of the right to be able to continue to speak freely. But it's also essential to even have self-government. It's essential to have social progress. It is essential to be able to have a pluralistic society where we live peacefully, when we can share what we believe in environments like this. The promise of free speech also anchors our other rights. So what are those rights that it anchors? Well, certainly our right to associate, our right to express and petition the government with our grievances, the freedom of our press, also our religious freedom, and the right to raise our children consistent with the values that inspire our lives. We all want that right. And free speech assures us of the ability to be able to think freely and to speak freely. So it's critical. So tonight, let me be clear. I believe that how the United States Supreme Court rules in 303 Creative will affect every single one of us. And that's why people who support same-sex marriage support Lori's case. I also want to just point out, for those of you who haven't met Lori, Lori's an artist in Colorado. She's a website designer. And she left the corporate world and the government world so that she could promote causes that are close to her heart. She loves to support animal rescue. She loves to help those who are homeless, and to eliminate homelessness is one of her goals. And she loves to support children with disabilities in her work. And yes, she wants to be able to promote her faith's view that marriage is between a man and a woman. Something else that I think is important to understand is that she wants to be able to expand that portfolio to create custom websites promoting that view. And in so doing, promoting custom websites, Colorado has told her she'd be violating the law, and they're preventing her from doing that. Because of this censorship, and frankly because she's had a front row seat at how Colorado continues to treat Jack Phillips, Lori challenged this law. So in closing, I just want to mention two facts that you may not be aware of about the case, because it's something that makes our case a little bit unusual. And that is that the parties in the case, Colorado and Lori, have agreed to a written set of facts. We call those stipulations for the non-lawyers. And there are a number of facts that the parties agreed to. The first most significant fact would be that every website Lori creates is custom. It's made for that couple to celebrate their unique story. And it is pure speech, as Sherif talked about earlier. It also has a celebratory message. Colorado has conceded that as well. So there's a message in every website. A second fact that's important for you to know that's already been agreed to by the parties is that Lori serves people from all walks of life. She has clients who identify as LGBT. She has clients who don't. She has Democrats as clients and Republicans and Christians and non-Christians. What Lori bases her decisions on in what projects to engage and what messages to express is about what the message is, not who is asking it. And that's why so many of those hypotheticals that David just mentioned aren't actually reality. And it's not how the discrimination laws have worked or will work if Lori wins. But I will say, under Colorado's theory, and I think under David's theory, it is a scary new brave world. It's one where we give the government the authority to tell us what we can and can't say. And frankly, right now, I'm not willing to do that. And I don't think that you should be either. And I don't think that the First Amendment allows it. So I'll just close with the idea that the incredible legacy that we have found in the First Amendment says that we get to speak our minds, that we don't lose our constitutional rights when we enter the public square, and that when we do speak our minds, it really doesn't matter how much the government or my neighbor agrees with me. And I think that's a legacy worth keeping. So we're standing not just for Lori, but for every artist and every American, and even those in the room tonight who don't agree with us when they leave here. Thank you.
Kristen, I want to start by I want to start by asking you, you mentioned Colorado's censorship of Lori, and I want to ask you to kind of talk about that a little bit, because in fact, Colorado hasn't said a word about Lori's websites, right? Because in fact, she hasn't created any that are at issue. No one's complained about them. So can you talk about that?
Sure, I can. It actually has said quite a lot about it over the last 6 years. So Lori filed her case. Actually, Jack Phillips' case wasn't even at the Supreme Court when Lori filed her initial case. And the Colorado court has repeatedly said that by entering into the wedding business, by declining to design custom websites that would celebrate a view of marriage that violates her objections, she would be breaking the law. In addition, there's a concept called standing for the non-lawyers that it kind of gets at in terms of whether Colorado has harmed her enough to file a lawsuit. In Lori's case, she clearly has an injury because she's, again, been threatened by Colorado, and she's had a front row seat seeing Jack. But in addition, even just 24 hours after filing the lawsuit, she received a request for a same-sex wedding as well. Even the lower courts that ruled against Lori found that Colorado has threatened her, that it's a credible threat of enforcement. And just like in the civil rights era, when African Americans were searching to have their civil rights validated, they filed what's called pre-enforcement laws. And that's a hallmark of the civil rights movement, and that's what Lori's done here.
Just want to ask you one more thing, and then turn to the others on the panel, which is one of the issues that Sherif mentioned as one of the difficult aspects of this case is where to draw the line and how to draw the line. And let's start by saying, is there anything that would prevent Lori or anyone else from refusing to make that website or any other wedding-related thing for an interfaith or interracial couple, because I don't believe in that?
I think we can look at the court's precedent to discern what tests they apply, and courts routinely decide between speech and conduct, and they routinely decide between message and person, message and status discrimination. And one of the ways that they do that, Sherif talked about the Hurley case, and Hurley kind of maps that out in this context. It basically says, first of all, is there speech? And those that were tracking our argument in Masterpiece Cake Shop, I think, would know that was a big issue, is whether you could have speech in the cake context. But here we don't have that issue. So you get to the next test, which is the request affecting the speaker's message? And is the government regulation affecting the speaker's message? In most of the hypotheticals that you've heard, there's absolutely no speech at all. And you look at what the objection is and compare that with what the message is they're being requested. You also, Hurley says, you look at whether the speaker is serving the same people in the class in other ways. And in the case of, for example, the interracial marriage, we know that often that isn't going to be the case. And I also think it's important that the Supreme Court has already made the distinction for us. Obergefell and Masterpiece note that people on this marriage issue, loving an interracial marriage was about white supremacy. It was systematic prejudice of an entire class of people used through public and private action. And the court said it was odious under the Constitution. In Obergefell, the Supreme Court distinguished objections to same-sex marriage by saying those are objections that are held in good faith, decent and honorable people hold them, they're reasonable religious and philosophical premises. So I do think this case is about holding the court to its promise in Obergefell.
So I'm not quite sure I understand whether if you oppose interracial marriage, you're in Lori's shoes or not? I mean, is it okay if I don't want to make a wedding website for an interracial couple?
No, it depends on what the message is that you're objecting to. And Hurley would tell us, look, for example, were the parade organizers otherwise serving those who identify as LGBT? Could they march in the parade? Was it truly the message that they objected to? And in the case of an interracial marriage, you're not going to have the message that's objected to. And even if you did in that kind of a circumstance, you would also have the compelling interest test. And we know under cases like Pena-Rodriguez that the historical and systemic prejudices against race in this nation may merit compelling interest. But never, ever before, and I guess I didn't say this when I opened, never, ever before, even in the most odious situations of speech, has the court actually compelled speech. It would be unprecedented. And the dissent in this case also said it's an existential threat to freedom.
David, do you want to?
So I think the answer is yes. on the argument that Kristen is making. A website designer that that objected to interfaith marriages could refuse to make wedding websites for interfaith couples on the exact same argument. What we're engaged in is speech, and I object to the message of saying it's okay for people of different faiths to marry. Same thing for race. Exact same argument. And the only way that there would be any distinction between the two would be if the court were to say there is a compelling interest in fighting race discrimination, which they've said. There is a compelling interest in fighting sex discrimination, which they've said. But there's not a compelling interest in fighting discrimination on the basis of sexual orientation, which I would be shocked if they said. There's a compelling interest in fighting discrimination, is what the court has said, and it hasn't said there's a sort of a tier levels where some kinds of discrimination the state has a compelling interest in, and others it doesn't. So I think on the argument that she is advancing, racists. She says, well, the court in Obergefell said, well, decent and honorable people can be opposed to same-sex marriage. I agree with that. But the First Amendment protects, as Kristen reminded us, everybody, not just decent and honorable people. It protects racists. It protects white supremacists. That's why the ACLU defended the rights of the Nazis to march in Skokie, because the First Amendment protects everybody. So if her First Amendment argument survives, then it protects the racist. And the bakery example I gave, I don't want to say happy birthday to a black family because I think black families should not be celebrated. That's my message. Putting happy birthday on the cake is expressive, and you're making me alter my message by making me sell to a black family what I would sell to a white family. That's exactly the argument that Kristen and ADF are making on behalf of Lori Smith. I don't think that's a world, as I said before, I don't think that's a world we want to live in. No one on this panel is a more devout defender of free speech than I am. I've spent my career, 40 years, defending the free speech rights of all kinds of people, from flag burners on, and religious dissidents as well. But there's not a First Amendment right to discriminate. This law does not tell Lori Smith she has to say anything. It just says if she chooses to say X in a service provided to a business, in a service in a business open to the public, she has to say the same thing for everybody. So Colorado has said very clearly in their brief, they've said Lori Smith could put on her website, on every website, she could put the Bible defines marriage as between a man and a woman. And she could put that there. They're not saying she can't put that there. What they're saying is that whatever she provides to opposite-sex couples in terms of a service, and here it's a website design that is very vague because there hasn't actually ever been a website because it's a kind of a pre-enforcement challenge. She's never actually made a website for anybody, but a wedding website could just be Jack and Jill are getting married on November 25th at the National Archives. The party the night before is at this place. Please come, and here's the gift registry. And she is arguing that she should have the right to do that for opposite-sex couples, but she should have the right to say no to do the exact same thing for same-sex couples. I don't think the First Amendment protects that, because what the law does is give her the right to choose what she wants to say, but just say, look, if you're going to open a business and serve the public, you have to serve everybody. It's regulating the conduct of selling, not the not the content of what you sell. You can. I'll close with this. The law allows you to open a Christmas store. You've all been to Christmas stores, and you can open a Christmas store. And you can sell only Christmas-oriented goods. You don't have to sell Hanukkah-related goods. So you get to choose the content of what you sell, just like Lori Smith gets to choose the content of what she sells. But if you have a Christmas store, you can't say, no Jews may patronize our store. Please turn around and leave. That's what she's saying to gay couples.
I wonder, there's a divide here, obviously, and it's between
Very perceptive.
Oh, thank you. That's why I do what I do. But are we talking about conduct or are we talking about speech? And maybe Sherif, can you explain a little about that? And while you're doing that, could you, the case you mentioned, Hurley, and the Boy Scout case, were both cases in which the organizations were told they didn't have to comply with what people wanted, the Gay Scoutmaster in the Boy Scout case, and of course the group that wanted to be in the parade. But those are, at least according to the briefs on the other side, those were unusual cases because they didn't involve commerce at all.
Yeah, and Hurley, one of those two cases, in the opinion itself, again unanimous for the court, written by Justice Souter, said, by the way, First Amendment protections apply to business corporations as well as everyday people on the street and private associations of all kinds. So it's impossible. Search all the amicus briefs, all the briefs in favor of Colorado. You will not find a convincing distinguishing of Hurley. It's impossible. And now you could say, well, look, they're going to have a precedent. They've overturned some precedents in the past, so they might do it again here. And then the question is, which of the key premises will they overturn? To just speak, and I think each one of those will wreak havoc on other areas of First Amendment law. That's why I make the bold, foolhardy prediction that I made at the beginning. But so just to get to your question on conduct versus speech. So, and maybe this is related first to the question about whether it really is the same product that's being denied, right? If you sell Christmas trees to Christians and a Jew happens to want a Christmas, this is a dumb example. If you sell, you sell any given product, take it back, you sell any given product, looks exactly the same, it's got all the same features, it's going to be used in a similar context. You can send it, you give it to gay people, you got to give it to straight people and vice versa, Jews and Christians and so on. I think that's a matter of common ground, and that if that's what the law is making you do, it's not making you speak something you reject, because it's making you speak something you already spoke, just to the other party. But that's a completely question-begging way to describe what's happening here. Go back to my other example. You have a website designer who makes websites for houses of worship, right? So a mosque wants to give you times for its services and so on. They'll make it for those, and maybe they'll have a message from the clergy and that'll go on the website and so on. And they do it for a Catholic parish and for an evangelical and all that. And then they get a request from the Westboro Baptist Church, which is an extreme and deeply hateful cult that in one major Supreme Court case was renowned for saying that God sent the 9/11 attacks to punish us for gay people and so on, and had slurs and everything. The fact that the website designer makes websites for other houses of worship does not mean that she has to make a website for here. Now, I think by David Cole's argument, the point would be she's providing a product to one group and denying it to another based on religion. That's religious discrimination. To which the response, and I assume David Cole would share this response, but he can speak for himself, would be no, those are different products. One of them is expressing benign messages about services on Fridays at the mosque or on Saturdays at the synagogue, and this one is expressing a totally different message. And it's the same thing within the context of weddings. It's not just a generic website. It's a website tailored to the particular couple that says this couple's relationship is going to be a valid marriage, it's going to be a marriage, they're getting married, and that this is something to be celebrated. So it's not the same product. The idea that there is conduct here, namely the sale, and that's separate from speech, is very hard to make sense of in this context because the sale is of speech that you created. And it's the process of creating that speech that implicates First Amendment values.
David,
so can I respond?
Please.
So, bookstores are protected by the First Amendment. The product they sell is clearly speech. They can't discriminate based on race or religion or sexual orientation or sex, even though what they're selling is clearly speech. The reason is that the question that the court asks in these cases is not whether the product is expressive or not. It's whether the government's interest in enacting the regulation is targeted at what is communicated by the product or the service or the conduct, or whether the government's interest in passing the regulation is targeted at conduct. And what the court has said is that non-discrimination statutes, public accommodation statutes like this, because they apply to all businesses, they apply to plumbing, they apply to bookstores, they apply to hardware stores, they apply to website designers. They're not targeted at expression. They're targeted at whether when you say you're serving the public, you actually serve the public. That's conduct. Do you put a sign up saying, no gay couples enter here, or not? That's conduct. You either let people in or you don't. And that rule, that what every state says is if you open your business to the public, you have to let everybody in. And it doesn't matter whether what you're selling is expressive or not. So the focus is not on whether the product or the service is expressive, but on whether the government's interest in regulating is targeted at conduct, irrespective of whether it's expressive, which is the case with public accommodations laws. The court has said these are the paradigmatic content and viewpoint neutral kind of law, or whether it's targeted at expression. So Kristen says the court has never allowed compelled speech before. Well, all the compelled speech cases that the court has ruled on are cases in which the government passes a law that says you must say X. You must pledge allegiance to the flag. No, you can't say that. You must put live free or die on your license plate. No, you can't specify a content and say people have to express that content. But you can say you have to treat everybody equally. And again, to a business that chooses, I mean, this is the thing that I think, makes Lori's case really not very sympathetic. She can make websites only for people she wants to make them for if she doesn't open a business to the public. And lots of artists, lots of designers do that. They work on personal commission bases and they have full right. They're not regulated by these laws at all. She's made a choice. With that choice to sort of get the whole public in comes an obligation. Sometimes choices have responsibilities, and the responsibility is you serve everybody equally.
Kristen, I sense
yeah,
you
I
want
gotta
to
go.
say something.
Because I disagree with about 110% of that. Let's start with the bookstores. We agree with you. Bookstores can't discriminate, and they're not creating speech. They're selling speech. That speech has already been made, and the court has made the line, and Lori is consistent with that line, that we're talking about custom speech. This is speech that's tailored to the couple. It's not something you buy off the shelf.
So
a book is done.
take happy birthday, and a custom
I'll
expressive.
take that every day and all day long.
Okay, go for it.
Because happy birthday is, when you look at what the message of the cake is, the court says you look at what is the speaker's objection. They're not objecting to wishing a black child a happy birthday. That is a status-based. There's no objection to that particular message.
Remember, that's the hypo. The hypo is I object to the message of saying happy birthday to a black family. That's a
status-based message that you're not objecting. That's not affecting your speech. There's no objection to the message of happy birthday.
Sure there is.
There's not.
You're saying happy birthday to a black family, and you think, look, I can't. If Colorado passed a law saying all bakers must say happy birthday to black people, that would be content-based discrimination. It would be content, because it would be defining a message, it would be saying you have to say this, and you have to say it to everybody. That would be content-based. But that's not what Colorado's law does. It says you don't have to create any message whatsoever. You don't have to put happy birthday on any cake. You don't have to create a website design service for the public for marriages at all. But if you do decide to do that, you can put whatever you want on it, but you have to sell the same service, the same product to the gay couple as to the straight couple, to the black family as to the white family. That's what's required.
And thankfully, that's what Lori does. She does serve the black couple and the white couple and the gay couple and the straight couple. She serves everyone. But what Colorado is saying in this law is if you dare to speak on marriage, you have to express all viewpoints and the viewpoint that the government wants you to.
No.
That's compelled speech. And I want to get back to this idea of conduct versus speech and when speech is compelled and it isn't. Because, I mean, there are cases that you have even litigated where the speech has been mandated, as has a course of conduct, Holder being an example. Cohen, which involves breaches of the peace. Clearly, a breach of the peace is aimed at conduct. It is not aimed at speech. But the court has said when you sweep in speech, when you say a law applies because of the message of the speaker, the state is compelling speech and that violates the First Amendment. And that's what happens here. If Lori does not lose her constitutional rights by entering the square any more than the LGBT designer or the pro-abortion photographer who's also going to lose their rights when Lori loses hers. And I think that's important because there is no limiting principle when you're writing a blank check to the government to say, take away these free speech rights. We trust you to manage them.
No, I think the limiting principle is you don't have to go into business to serve the public at all. It's just a condition of making that choice. And we do not regulate what you say. You can, again, she can determine what she wants to put on her website. And Colorado has nothing to say about that.
Well, that's
Nothing.
not what Colorado's
No, that is
said.
what Colorado actually said. It is perfectly fine for Lori Smith to put on her website, the Bible defines marriage as between a man and a woman. And as long as she's willing to sell that website design to gay couples as well as straight couples, she hasn't violated any law whatsoever. So they're not trying to control the content of the speech. They're leaving the content up to her. They're just saying, once you say something, you got to sell it to everybody. That's all they're saying. And that's a regulation of the conduct of sales, not a compulsion of any particular content of speech. And that's why every time a First Amendment objection has been made in the past, it has lost.
So there is one thing that I think is just a false description of the facts, which is that you said in every compelled speech case, there's the government's interest, in every case where the compelled speech claim has won, the government's interest was in the nature of the expression. But it's in, again, I hate to come back to Hurley, but it's in the opinion that that the anti-discrimination law there in general, as Justice Souter pointed out, was just targeting discrimination. And he said in the mine run of cases, there's no First Amendment problem. When it's applied in a way that has the effect of compelling speech, then it is a problem under the First Amendment. And he said, that's the issue, and I think this is on all fours with that. In the case of the book, when the bookstore has to sell a copy of Moby Dick to black people if it sells it to white people, the content of Moby Dick is exactly the same in both cases. But if the bookstore, if there's an author who's sitting doing a book signing and autographing copies and one person, some very sympathetic person comes along and says, could you write me a nice message in the autograph? And the author says, dear so-and-so, I'm so pleased that you're reading my book. Please follow me and, best wishes. And then the next person comes along, a deeply unsympathetic person, and this person that publicly stands for things that the author opposes, and the author says, I'm not going to sign a message saying nice things about you. Would you say that that's the same thing being offered to one and denied to the other, or is it a different message? And if it's a different message, why isn't it a different message here?
So I'd say that wouldn't be covered by public accommodations laws because there's no public accommodation law that says you have to treat people equally whether you like them or not. It says if you treat people differently because they are gay, straight, white, black, female, male, and that didn't include that.
Two things about that. One, there are, and again in D.C., there's a political affiliation anti-discrimination.
I think that's
so if this is a member of the Proud Boys.
Yeah.
But second, the point is, my argument was not about whether it's covered under the statute. That's separate from the constitutional question of whether it would be a compulsion of speech that raises strict scrutiny if somebody was forced to do that.
I guess the question for you, Sherif, is what do you say about the college application editing service that's open to all, but the owner objects to too many Asians in elite colleges, and so he refuses he's provide the same service, and it is custom service, it is expression, and he says no Asians need apply.
He's not, if if what he is doing is making sure that their thing is well edited, he's not creating speech that says Asians are great or Asians belong in
So editing is
colleges or
not
something
expressive.
like that.
Editing
well,
is
it
not
depends.
expressive.
So you can imagine a scenario where he says, like, look, I'm part of my editing. I'm going to help you cheat a little bit through the application process. I'm going to write you
By definition,
paragraphs.
that's what these things do, right?
I'm going to write you. I'm going to write a paragraph that talks about things that you haven't mentioned, content you haven't brought to me. I'm going to be creating it, and I'm going to say, these are all the things that make you a good fit for
Yeah, and
college.
I won't do it for Asians.
And if he thinks that they're not, so
No,
here's
that's the question.
No.
Can he say, I won't do that for Asians? I'll do it for everybody else, but not Asians.
it depends. If he thinks they're not good fit, I agree that it's for the courts, not the claimant, to say whether something is expressive. And it's for the courts, not the claimant, to say what the content of the expression is. And it's only for the claimant to say what content they agree with or reject. So if the claimant is using compelled speech doctrine as a pretext to just not serve people they don't like, which presumably would show up in other forms of denials, that's one thing. But if they're actually refusing the message, then yes, it's compelled speech for the same reasons that you're talking about, which is that the First Amendment exists to protect deeply discriminatory. So I just want to know, what is the answer to any of my hypos, either about the Dobbs, you do websites for parties. That sounds like a product. And someone asks you to do a website celebrating something benign, and you do it, and then some Republican or conservative pro-lifer or Catholic claiming it's rooted in a religion says, I want you to create a website celebrating Dobbs. And you're a website designer who thinks women are suffering all over the country. In some states, they're dying because of Dobbs. And I don't want to create a website advertising a
my
party
answer to that is,
Dobbs.
as long as you don't want to create a website that says Dobbs is a great decision, and you would not create that for anybody, you have the right not to create that for anybody.
That is an astonishing response.
No, it isn't, because look,
from you, because in here we can define it in terms of propositional content, which is what you did, and I agree with it. Here's the propositional content you don't want to either directly say or imply, or say something that entails it. Dobbs is awesome. Okay. So that means if the website says there's a Dobbs party, come celebrate, the person can refuse that. Well, here's some propositional content Laurie Smith doesn't want to promote, either communicate herself or say something that entails it, which is same-sex relationships are marriages and to be celebrated as marriages. And so now it turns out if she makes a site for John and Jane, she's not doing that. And if she makes a site for John and Joe, she is. What's the difference between those?
So on that theory, then she could also say, I will not make it for interfaith, no interracial.
I think so. Look, of course it's uncomfortable, but the way I'm going to think about it is, at what step do I get off the boat? So let's start with, can you ban books that oppose interracial marriage? And everybody would say, no, that's book banning, that's a First Amendment violation. All right, can you require someone to write a pamphlet or a book or whatever that celebrates interracial marriages? No, that's compelled speech. Can you compel them to make a website that celebrates interracial marriages? Absent a compelling interest in each of these cases, the answer is no. Nothing has changed from banning to compelling from a book to a website. So now the question is, well, why is this case different? The only possible account would be that there's a compelling interest in providing the service because there's a lack of access to this kind of service for a group within the community, and nobody has suggested that that's true. So it's on all fours.
Well, I mean, I think first of all, I don't even think you get to whether there's a compelling interest, because it's a regulation of conduct. It applies to all businesses, regardless of whether they express it or not, in exactly the same way. And therefore, you only apply, the deferential scrutiny. And secondly, even if you applied compelling interest, there is a compelling interest in ensuring that every person is treated equally by businesses that are open to the public. That is a compelling interest. That is an interest that every state in this country has had laws on the books for over 100 years requiring that kind of treatment. We all expect it. None of us want to walk into a store, no matter what they're selling, whether they're selling something expressive or not, whether they're selling something custom or not, and have it say, Catholics need not enter here. Because I religiously, I'm an atheist, And I think Catholics are, really, everything about this country that's wrong is because of Catholics. By the way, I'm Catholic, so this is a hypothetical. But if I believe that, right, and I believe that in good faith, I have a First Amendment right to say that, surely. And so by the argument that Sherif and Kristen are making, it would be compelled speech for me to have to serve Catholics in a way that I object to. And again, I think the history of this country is no. When you go into business to serve the public, you serve everybody. That's a regulation of conduct, not a regulation of speech. And there's no escape clause for the many, many businesses, whether it's attorneys or landscape architects or architects
David,
or editors.
I'm sorry, we're going to open up to questions in a minute. I do think Kristen's been, want to give her just a chance before
I've been
you
trying
do
to
that.
be patient. I think the only other point, I think it's clear that the examples of the whites only and those kinds of things, those just aren't applicable here. There's not speech involved. It's just not on all fours. But what I don't think has been raised yet, and I don't quite understand in terms of your position, is when we look at public accommodation laws at the city level, the county level, the state level, the federal level, they are proliferating in terms of the categories that are put in. Madison right now has 24 different categories that it protects. We know politics is becoming a protected class. And on top of that, the mom who wants to just raise some extra money, who posts on Etsy, is under Colorado's public accommodation law. You don't have to open a business to be subject to this law. You just have to sell something, anything, and you become subject to it. So it's broad and it's deep. And I can't imagine that your position would be that a pro-abortion photographer who's going to shoot, a rally that is promoting one view is going to have to go do March for Life. And to say that, in the marriage context, well, if you speak on marriage in one view, you have to speak on the other, seems like the same thing ought to be true with regard to promoting a religion, promoting abortion, or not promoting it.
I think the pro-abortion photographer, like the pro-choice writer myself, I don't serve the public. I'm not open to the public. I earn money writing, but I write what I want for whom I want, and no public accommodation law governs that. And yes, public accommodations laws have broadened because we've recognized that actually people deserve to be treated equally, not just on the basis of race, but also sexual orientation. But it's interesting that it's only when the laws required that people be treated equally on the basis of sexual orientation that ADF stood up and said, hey, wait a minute, there's a First Amendment problem.
No, you give me that political case, we'll take that all day long.
All right, so I'm going to stop you guys here for a minute and see if there are any questions from the audience. And if you have questions, there are microphones on either side, if you could come down.
Mr. Cole, in the Masterpiece Cake Shop case, I believe your side took the position that the wedding cake was not speech. Now tonight, you appear to be saying that birthday cake is speech. So if you change your position.
No, that's not what we said. What we said was we acknowledge that if the cake, even if the cake is speech and it's expressive, the question is not whether the product or the service is expressive or not. Under the law, the question is, why is the government regulating? And if the government is regulating regardless of the content of what's expressed, then you apply this deferential standard and you uphold the law generally. And anti-discrimination laws apply, as I said before, both to expressive businesses and to non-expressive businesses in exactly the same way. They simply require that if you're going to sell something, you sell it to everybody. And so the law is not targeted at expression. So, I've always argued that the question is not, is this expressive or is this conduct? That's a hopeless endeavor because virtually all conduct can be expressive. A punch can be expressive. Almost anything can be. This pen can be expressive. The way I move my hand can be expressive, right? But it's also conduct. So that's a fool's errand. And so instead what the court has done consistently is say, what is at stake here in the government's regulation? Is the government trying to control speech? Is it targeted particular expressions and said you either have to engage in them or you can't engage in them? That's a First Amendment problem. But if they haven't done that, and they've said, no, you just have to, whatever you decide to say, whatever you decide to sell, you got to sell it to everybody. That's not a speech problem.
Oh,
That's the argument we made in Masterpiece Cake Shop, and that's in fact what the court says in Masterpiece Cake Shop. It says, as a general rule, the fact that you have philosophical or religious objections does not permit a business to evade anti-discrimination law.
And certainly that would be true as a general rule. I thought you also argued in that case that the wedding cake was not speech.
No, we didn't argue that. We argued it doesn't matter. That's just the wrong question. And you can listen to my argument. That's the wrong question. The question is the government's interest in regulating this directed at what the speech, what the conduct communicates, or is it not directed at what the conduct communicates? And again, a law that treats everybody the same, every business the same, whether you're a bookstore or an editing service or a plumber, treats you exactly the same.
Let's
Another
go on.
Another question has to do with.
Sir, I'm sorry, there are
Oh, I'm
other
sorry, go
people
ahead.
waiting, so I'm going to
Sure.
move over here.
Thank you. Ismail Royer from the Religious Freedom Institute. Thank you, Professor Cole. This is it's really wonderful that you came and are addressing this in this in this forum. So I wanted to isolate the variable a little bit. If the customer who was coming to the website designer was not gay, but was actually someone who was straight and said, I want to create a website that celebrates same-sex marriage, but I'm not gay myself. And if the designer said, no, I don't want to do that because of it would be forcing me to, to express something that I don't believe. Would the fact that the identity of the person who is the customer is not of the protected class, would that make her decision not to do the website legal or illegal?
So that's a great question. I mean, I think I actually don't know the answer to that question without more details. If the customer is, say, for example, in Masterpiece Cake Shop, if it was, instead of Charlie and Dave, our clients, it was Charlie's mom asking who is heterosexual, asking the baker to make this cake for a same-sex wedding, and he would make the exact same cake for an opposite-sex wedding. The only thing that's different is for whom it is ultimately being used. Yeah, that would be discrimination based on identity. So it's not always going to be the identity of the person there. If a white customer comes into that racist baker that I keep coming back to and says, I want to buy a happy birthday cake, and the baker says, well, who's it for? If it's for your kid, I'm happy to do it, but if it's for a black kid, I'm not, because I object to the message of saying happy birthday to black people. That would be race discrimination, and that would not be permitted, even though the customer is white.
Sorry,
If the ultimate beneficiary is not of a protected class, let's just say it's a cake that says.
Oh yeah, so no. I mean, then it would be. Then I think if you're saying, look, I come in and I say, let's say I go to a T-shirt manufacturer and I say, I want to I'd like a T-shirt that says Black Lives Matter, and the T-shirt person says, we don't sell that to anybody. That's not something we would sell to anybody. That's not discrimination based on the identity of the customer. That is message-based discrimination.
Well, this is a remarkable.
And this is not a remarkable. This is not a remarkable concession. This is much about this case turns on whether you characterize it and whether you understand what she's doing as message-based discrimination, which Kristen tries in her brief mightily, and Sherif tries mightily to kind of fit into, or whether it's identity-based discrimination. Here's what she's asked for. She wants an order saying, I don't have to provide website design services to any gay couple. That is not,
That's
I don't
not
have,
true.
that is,
That's
that,
not
I don't,
true.
that is a quote from
You
the.
mean wedding website design services?
Yeah,
Okay, first
yeah,
of all,
wedding website
but even
design
that's
services.
not entirely.
Well, that is a quote from your request for relief, and it's in the U.S.
Can I say why
Solicitor
it's
General's amicus brief.
remarkable?
So I think it's identity-based.
Here's what's remarkable. He's basically saying you're allowed to refuse to create a website that would celebrate same-sex marriages if you're opposed to celebrate same-sex marriage if you're opposed to same-sex marriage. You're not allowed to refuse to create websites celebrating same-sex marriages. That doesn't make any sense. I mean, if it's okay
If
to
I
refuse.
said that, it's true, it wouldn't make any sense.
That's what, and I think that is.
But I don't think that's what I
So
said.
in the scenario where the person who, it's a straight person who's just trying to, wants to celebrate and promote same-sex marriage. So they ask for a website that promotes same-sex, that has content promoting same-sex marriage. The person says, sorry, I disagree with that view of marriage. It sounds like you're saying, and there's no protected identity issue in the picture. It sounds like you're saying it's okay to refuse that because forcing you to make that would be compelled speech.
Yeah.
But now the question is not to create a website celebrating same-sex marriage in the abstract, but creating a website celebrating this same-sex marriage or that same-sex marriage, and you say the result is completely different. How could that be?
The result is only different. Again, and Colorado has said this, and the United States has said this. If you're not willing to sell something to anybody, you don't have to sell it to anybody. If you're, that is because you're not discriminating. So I won't sell a Black Lives Matter T-shirt to anybody. That's not race discrimination. I will sell a Black Lives Matter T-shirt to black people, but I won't sell it to white people. That's race discrimination, and that's what Laurie Smith is saying. I'll make a wedding website design for any opposite-sex couple. I will not make one for any same-sex couple, even if the text on the two websites was identical. And that's the same thing with Jack Phillips. He didn't even know what the design of the cake was. He says, I will not make a cake, custom service cake, for any gay couple because that would express my support of same-sex marriage. So yeah, it's identity-based discrimination.
And if the texts were different, do you think the result would be different? You said even if it's the same text on the websites. If the text is different?
If the text is different to the extent that, yes, she says, and it's plausible, I would not sell this to anybody. Nobody's required to sell anything.
Wait, so I agree with you that if you're just being forced to sell the same thing you would sell to others, there's no compelled speech problem because you've already said it. But it's just obvious that the two websites, one celebrating this couple's marriage and their opposite sex, the other celebrating this couple's marriage and their same sex, are carrying different messages.
Well,
how could that not be true?
Well, providing editing services for an Asian student is obviously sending a different message if I'm a racist than providing editing messages for editing services for white students. So in that sense, if you reduce the message to identity, then you've got a problem, and it's.
And is that what's happening when the website designer who makes websites for houses of worship will make them for everybody except the Westboro Baptist because their request includes the pastor's message that's full of vile anti-gay bigotry?
No, because then the reason would not be because of their religion. It would be because anti-gay bigotry.
But the anti-gay bigotry is a part of their. It's an expression of their religion.
We're not saying we won't provide services for any Baptist church. We're saying
and she's not
this
saying
particular Baptist church.
And she's saying we won't provide. Oh, so it's okay. So it's okay to discriminate against some Baptists, but not others. Is that what the view is?
No, it is permissible to. It's not identity-based discrimination to say, I don't like what you have to say. That's message-based discrimination. It is identity-based discrimination to say, I will provide the exact same service to an opposite-sex couple, but I won't.
I would love for everybody leaving here to leave with the view that what matters is whether the messages being created on the websites are different. If that's what the case comes down to, it will be it may be better than 7.2, though I'm only sticking to the 7.2.
I think also it ignores the fact that context does matter even in when same or similar words are used. And I don't know how we can escape that fact. I have a hard time thinking that when you have a band that's going to perform, does the band that has a website out, which public accommodation law would cover that band, do they have to perform for Trump if they just want to perform for Biden at his inauguration? No, right? But it's the same words, it's the same song. There's no difference.
So first of all, most bands do not, say we'll perform anywhere. We'll perform where we choose to perform. They're not opening their business to a public. Number one. Number two, you guys keep coming back to the political affiliation discrimination, which is there are 3 places in this country that have political affiliation bans in their public accommodation laws. I think those raise independent First Amendment concerns. But yeah, if you're, let's say you're a band and you say, I'm going to open a recording studio. And I'm going to say, it's a recording studio that's open to the public, but I won't record songs by gay people or Catholic people or Muslim people or whoever I am a racist or a religious bigot or otherwise object to. Then you've opened the business to the public, and yes, you do have to serve everybody equally.
The opening of the business to the public matters for whether the case falls under anti-discrimination laws as they are currently written. I cannot see how it matters to whether there's a compulsion of speech. There's no basis for, if it's a contractor who does case by case, and you say, look, you can refuse for all kinds of reasons, you're just a contractor, but you can't refuse because of race or sex.
It matters because there's no compulsion to go into business to serve the public. You have
no,
made a
that's
choice.
my example is someone
choice.
who's not open to the public. They do, on a contract basis, provide a particular expressive good or service. And you say, look, you're a contractor, you can refuse for all kinds of reasons. You just can't refuse because of race, sex,
No,
etc.
you can if you're a contractor.
I'm saying if an anti-discrimination law were expanded to say that, how would the constitutional analysis be any different because there's not an opening to the
that none of
public?
them have, and I think it's because they
For
recognize...
policy reasons, not for constitutional.
I think it's because they recognize that there is a... when you choose to open a business to the public, you're getting a benefit. You get to sell to everybody. You can, you have a bigger audience. You get more income, presumably. There's a condition on that, which is we want the marketplace to be open to everybody. So if you choose to enter that marketplace to serve the public, you actually have to do that. That's all this law says. It doesn't say we're going to compel artists to serve people they don't want to serve. Laurie Smith does not have to serve the public. She could make as many opposite-sex wedding website designs as she wants to and never make a same-sex wedding website design if she didn't choose to benefit from opening her business to the public.
And that's a powerful
Kristen,
policy
how about
argument.
a rebuttal? And then we're about out of time. So.
I think that the phrase open your business to the public is convenient to use here, but we both know that public accommodation laws cover people that are the freelance writers. This is not storefronts that we're talking about. I would also end with, we have clients right now, photographers, the kind that you're talking about, that are literally facing jail time, because they will not photograph same-sex weddings and create stories and blogs that celebrate those. That is a very different message than what their faith teaches them. And we should all, whether we support same-sex marriage or we don't, have the freedom to be able to speak our beliefs. That's the promise of the First Amendment. And the fact that we're in a situation right now where jail time is at issue because of that should be frightening to all of us, as the Chief Judge Timkovich said in his dissent. It is an existential threat to freedom.
All right, well, thank you all very much. I'm going to turn the program back to Greg.
Well, if you came here expecting a spirited debate, I think you got what you came for. I want to thank our panelists and moderators one more time, so if you join me doing that.